Hey, good morning. Welcome. We are back in session. We are on our second case of the morning. I am Meredith Sasso. I'm joined today by Judges Traver and Neighborhouse. Just so you all know, we are being live broadcast and recorded on YouTube. The case we're hearing now is Jonathan Forrester versus the School Board of Sumter County. Unless I hear otherwise, we will reserve 5 minutes for the appellant's rebuttal. And with that, Mr. Hawks, you may proceed.
Thank you, Your Honor. May it please the court. My name is Paul Hawks. I, along with Cord Bird, represent Jonathan Forrester. Jonathan Forrester was employed by the Sumter County School Board as a math teacher at South Sumter High School. Jonathan Forrester was denied the right that he had to carry a firearm securely encased in his vehicle, and the lower court found that in fact he was wrongly denied, and the question before the court is not whether or not he was wrongly denied, but whether or not he was adversely affected. We argue that of course he was adversely affected. He was adversely affected because carrying a firearm we're not authorized to on school grounds is potential criminal liability. They admitted in the request for admissions, which was presented to the trial court, that he would be disciplined if he violated the rules. Discipline could include job loss. He was also adversely affected because if he were accused of carrying a gun improperly on school grounds, it would affect his future employability potentially. And so he was facing fairly severe consequences if he carried a gun, even though he was confident that their rule did not do what they said it did. He attempted to work it out. He first went to the administration, talked to administration told him no, he couldn't carry a gun. He then, in his car, he then wrote a letter to the Attorney General's office. The Attorney General's office inquired evidently, and the school board responded back and saying, we have taken advantage of our statutory option, and the Attorney General wrote him back. He then retained counsel, which is another aspect of his adversely affected, and counsel wrote a letter to the school board telling the school board that in fact the rule did not prohibit Mr. Forrester from being able to carry a firearm securely encased in his automobile, and he received a negative response to that. He then filed suit.
Mr. Hawks, do you view the operative statute in this case, 790.33, like our sister courts do, as a standing provision?
Yes, I do think that it defines when you have standing. And 790.33 says that if they enact a rule or a procedure that denies the right, then they would be violating the preemption. Or if they enforce a policy or a rule. I mean, maybe a sheriff's department has an unwritten policy that says we're not going to return any firearms to individuals without a court order, which is fairly common. That would be in violation of the preemption.
What record evidence is there that this policy was enforced against your client?
Well, they of course searched his automobile, another aspect of being adversely affected. They told him he couldn't. They told him he would be disciplined if he did.
Where does that come from? They told him that he would be disciplined, that he did. Does that come from the answers to the requests for admission?
It comes there. I think that it was also testified to at trial. I mean, I don't have the record site, but I mean, it was certainly, and it was never, of course, contested, and they maintained throughout the entire trial that the rule that they cited, in fact, prohibited Mr. Forrester from being able to carry a firearm securely encased in his automobile. And they maintained that their rule achieved their desired goal. We maintain that it did not.
So the requests for admission don't appear to have been part of the trial record. And just in terms of looking elsewhere as to what was part of the trial record, as it relates to how it was enforced against him, I'm just wondering if you had any citations for me for that.
I can look, Your Honor, but I don't off the cuff have a record, because in fact it really wasn't contested. The whole issue at the trial between the school was, on the school board side, was that their rule prohibited him from being able to do that.
Let me ask it to you this way. Assume a different fact pattern. Assume that this issue had arisen and that the school assured your client in writing that this policy would not be enforced against him. Would he have standing at that point in time?
No, they wouldn't. He wouldn't. But that isn't in part based upon the facts of this case, because this rule had two problems the trial court found, both of which we argued. One, it was defective because if it was an effort, it was defective if it was an effort to prohibit him from carrying the firearm securely encased in his car. It was defective because it did not cite, as is required by Chapter 120, the statutory authority to enact the rule, and also, in addition to citing the statutory authority, the rule is supposed to cite what statute is implementing. This rule, 3.40 at the time, did not do either of those, so it would have been an invalid rule even if it had used the correct language. But then it was also an invalid rule, the trial court found, because it did not use the correct language. Obviously, citing from the appellee's brief, words have meaning in law, and firearm is specifically used in the provision, in fact, about 790.115 that gives the school board the authority to exempt themselves from the provisions of 790.25. It says that they can exempt themselves from the provision of carrying a firearm in the car. That same statute prohibits anyone on school grounds from carrying weapons, which are defined in statute. And they're not, a school board, for instance, is not allowed to exempt from the prohibition against carrying a weapon by the same authority. So it's a firearm. Firearm is the term of art. So under the facts of this case, if they had said, you are correct, Mr. Forrester, this rule does not apply to that situation, and you can carry a firearm as long as it's securely encased in your car, he would not have standing because they would not have enacted, nor would they have enforced a rule that violated the preemption statute of 790.33.
The statute does, tie adverse effect to promulgation or enforcement. Which bucket do you think this case fits better into?
Enforcement.
Or is it both? Sorry.
I mean, I think that the way they interpreted it could be argued to be both, but certainly, Mr. Forrester, it was enforced against Mr. Forrester. And of course it was enforced. I mean, to ask him, in Appley's brief, they talk about he was never fired, of course. He was never disciplined, but those are awfully harsh steps. I mean, normally we try to mitigate damages in law, not aggravate damages. And in part, the school board seems to be arguing he should have aggravated his damages. He should have told the administration, I don't care what you say, I'm going to carry a firearm. He probably would have been arrested or potentially would have been arrested. That's a felony offense. There's an old saying, you can beat the rap, but you're not going to beat the ride. So maybe he would eventually prevail in this criminal case, but obviously that's a traumatic requirement to go through when the legislature has spoken. It's not unlike public records, where the legislature, there's a constitutional right to public records. The legislature says if the executive doesn't turn over public records when they're requested, they have to pay attorney's fees. Here, there's a constitutional right to possess firearms in the state of Florida. There's also a national right, and the Florida Carry versus University of North Florida, 133 Southern 2nd 966. It's cited in the brief, but they held that because of the language of the Constitution, which says the right of the people to keep and bear arms in defense of themselves and the lawful authority of the state shall not be infringed, except that the manner of bearing arms may be regulated by law. And so what the First District Court of Appeal in Florida Carry ruled was that when the legislature writes statutes, they are in fact defining the constitutional right. It is a constitutional right that's being impaired, just like the public records. And so they've imposed attorney's fees, injunction, and other sanctions for local governments that in fact violate the preemption.
So going to adverse effect and the definition of adverse effect, obviously not defined in their statute. And I think in your brief, you argue this court should adopt a irreparable injury sort of standard while acknowledging that federal standard is stricter than adverse effect as it's used in Florida law. Can you bear that out a little bit?
Sure. I mean, what we're trying to illustrate is that the language of the statute, we think, reflects the case law that exists on when you deny someone their rights, what remedy do they have? And so I filed a notice of supplemental authority last night on a case that came out of the United States Supreme Court yesterday. And in that case, the individual wanted to hand out religious tracts on his college campus. He was denied, or a law enforcement officer told him he couldn't unless he went to a free speech zone and he got previous permission to go to the free speech zone. He did that. He was in the free speech zone, and they came up to him again and said, people are irritated by you doing this, and so you have to stop, because in our free speech zone, you're not allowed to make people feel uncomfortable. They started to defend the case, but then they stopped defending it, and they said, we've withdrawn the rule. You can hand out religious tracts anywhere you want on the campus. And they said, your case is therefore moot. And the 11th Circuit held, in fact, that it was moot. But the Supreme Court said, no, it's not moot. Nominal damages are sufficient to have standing to bring the lawsuit, because you are, in fact, damaged because you've been denied your right.
And that went to redressability in the context of Article 3 standing. Wouldn't adverse effect to be more analogous to the injury in fact component when you're putting to the federal standard of Article 3 standing, which might be even more broad?
Yeah. Yes. I mean, we think that, and yes, to answer your question, I don't.
So, and I'd like to ask you something. If we agreed that there was an error in the application of the adverse analysis component, so essentially the trial court here found that there was an adverse effect, but that your client consented to the adverse effect. In your opinion, what does the remand instruction look like?
Well, first of all, we think that there's more adverse effect than the search. I mean, the search is obviously a public humiliation, and we would submit that in the Fourth Amendment context, of course, we don't even think that there was consent. When your employer comes up to you and one of your employers is represented by a uniformed deputy and asks if they can search your car, and you're without benefit of counsel, and you know, that's not really consensual.
Seems like the first time that argument was raised was in a footnote in the reply brief, though. It certainly wasn't argued at trial, correct?
I don't think it was argued that directly, but it was argued that it was an adverse effect. I mean, the fact that this stuff was searched was argued as an adverse effect. But we think that adverse effect goes much beyond whether or not his car was searched. We think I mean, if we say going to the administration and asking, going to the Attorney General and asking, retaining counsel to write a letter and asking, and the school board can continue to say, no, you're going to have to subject yourself to employee discipline and potential arrest before we'll ever concede that you have standing, seems to be a pretty harsh standard for an individual who attempted in every way he could to try to work this out short of litigation. He didn't go running to court as his first remedy, and although he probably could have under the law. He likes being a teacher. He didn't want to jeopardize his teaching career, and he attempted to proceed in a manner that was reasonable and rational, and I'm a little bit, I don't know what else he could have done. I mean, he was truly adversely affected by not being able to exercise the rights that he has under the Florida Constitution, as articulated by the Florida legislature when the Sumter County School Board purposely and willfully violated the Preemption Statute, even though they were repeatedly told that it was in violation.
I think I stepped on Judge Sasso's question. Could you address, if we do see it your way, what the remand instructions would look like?
Well, we think that there is a remand and a remand for the determination of a reasonable attorney's fee, a remand of whether or not an injunction is appropriate, a remand for cost. Obviously, he had a filing fee and deposition fees and things along those lines, so there's cost. And perhaps a consideration of some of the other relief that may have been asked for. But
so you asked for injunctive relief in that the policy not be enforced at all is the way that I read your complaint. I guess I'd ask you, other than how it was specifically enforced, if we agree that it was enforced against your client, what's wrong with the policy? Why, for example, would the policy be eradicated completely when it deals with illegal substances and weapons?
Well, I guess then that the injunction would be to enforce the policy against the firearm securely encased in the automobile.
So you're not asking, in other words, you're not asking for us to enjoin the school board from enforcing the policy. You're not asking us to strike the policy down. You're asking on remand that we direct the trial court to just not enforce it against your client.
Right.
As it relates to firearms, obviously he couldn't bring a tear gas gun or cocaine or any of the other things that the policy prohibits, correct?
That is correct. And we have never maintained that their rule was a bad rule. We've only maintained that their rule did not achieve, just like they have a rule about how bus routes are determined or how the school nurse will operate or how discipline for students or how teachers are hired. I mean, they have hundreds of rules. None of those rules affect our client's ability to carry a firearm securely encased in his automobile. And that's what we said about this particular rule. So you're correct. We never said this rule was bad. We said this rule did not do what they were attempting to make it do against our client. And with that, I will reserve the rest of my time for rebuttal unless the court has further questions.
Thank you.
Thank you.
Excuse me. You ready for me, Your Honor?
You may proceed.
May it please the court, Stephen Johnson. I represent the School Board of Sumter County, Florida. In this case, I'd like to start by going over some of the things that Mr. Haught brought up during his argument. There was a discussion about the standing and the adversely affected. Obviously, we think this is a statute that allows for individual citizens to bring claims and has as its standing the requirement that there be some adverse effect for those particular individuals. Mr. Hawks indicated that potentially the effect was severe on Mr. Forrester in that, number one, he would be disciplined. Well, it's in several places in the record that was not the position of the school board, that he would be. He could be, I believe, were the answers to the request for admission and the testimony that was given. He could be disciplined as any other employee would be disciplined for any other violation.
What about Mr. Johnson? And I know because I asked a couple of those questions.
Yes,
what
sir.
about the deposition of Mr. Forrester that got put into evidence? It seemed that he had testified in that deposition that he was directed by the school board that he had to park off-site if he wanted to bring his gun with him to work, and that he could only park on school grounds if he didn't bring his gun. How is that not enforcing a policy against him?
Well, Your Honor, the incidents that gave rise to this entire lawsuit occurred back in 2017 in April, when a student reported that Mr. Forrester had stated he had a gun in his desk. At that time, there was the search of his room, and Mr. Forrester has admitted, quite frankly, throughout this claim that he is not allowed to bring a gun. No one's allowed to bring a gun into a school building. And so there was a search of the building where Mr. Forrester's classroom was located, and then a law enforcement officer, without a administrator or representative of the school district, asked Mr. Forrester if he could search his car. And that law enforcement officer, and the testimony is it was just him and Mr. Forrester, went out to the car, and that law enforcement officer searched his car. And then there was no gun. There was a copy of the statute relating to guns in his car.
Yeah, I think, and sorry to interrupt, Mr. Johnson, time being limited and all, I think we're all familiar with the factual background of the case. My question just had to do with the parking. How is telling him that he can't park at the school if he brings a gun not enforcing the policy against him?
It would be enforcing the policy against him.
So if we have, sorry, go ahead, Judge.
No, go ahead.
So if we have record evidence in the form of the deposition that has his testimony in it saying that he can't park there, and that's what the school board told him, and that's not objected to. How is there not? It sounds like you're viewing that statute like Mr. Hawks is, which is a standing statute. We know that injury in fact for standing is a super low standard based on the case law. How does that not mean that he's adversely affected by that statute?
Well, Your Honor, he never requested to park somewhere else from the very beginning of this incident. He actually, when he consented to the search of his car to the police officer on that same day, he had told the principal that he would not bring any kind of gun to school until this matter was resolved, I believe is how he put it. You know, there was no gun involved. There were 2 reports of Mr. Forrester saying that he had a gun in his desk in school. There never was a gun. There wasn't a gun, obviously, in school. There wasn't a gun in the parking lot. None of the searches that took place up until Mr. Forrester filed this lawsuit were initiated or directed because of compliance with the policy. The policy had nothing to do with it because inside the building, it was clear to everyone that it was illegal for Mr. Forrester to have a gun inside the classroom building. So those searches were under a completely different statute, which prohibits people from having a gun on school campus, and that if there was no exception for bringing it in your car. So those 2 incidents are really not related to enforcement of a policy. They're related to enforcement of a criminal statute of having guns on campus.
Let me ask you this. Do you agree with Mr. Hawks' statement that there's no question in this case that the school board intended to enforce or, either upon a violation or intended to have this as an actual regulation rather than just a policy on the books that would never be enforced against any of its employees?
I don't think there was any testimony that I can recall at all about what they intended to do as far as what if Mr. Forrester had a gun in his car, what would happen. Because Mr. Forrester had kind of stopped all of that discussion when he made this statement to the principal that he would not bring a gun onto school. Not that we are aware of that he had up till that, but he would not bring a gun onto school campus until, quote, this was resolved, close quote.
So what do we make of the testimony that Mr. Forrester testified that he faced the dilemma of being disciplined or fired by the Sumter County School Board if he brought his firearm in his car? The policy was promulgated and amended in 2019 to accurately fit into this exception, and that there was that discussion with the principal that he would not bring his firearm with him.
Well, I would point out that was the judge's ruling that it accurately fit this particular situation, the amendment in 2019, but in my review of the record, the amendment of 2019 was never made a part of the record. And I believe the only reference to it primarily was
testimony, though.
Ma'am?
Wasn't that borne out in testimony?
I think it was borne out in argument by counsel at the trial and closing, talked about having seen the new policy on the internet site for the school board, but the actual policy, I don't believe was ever brought in or testified to exactly what its impact was. The superintendent, I believe, testified on more than one occasion when he was on the witness seat that he wasn't exactly sure. He assumed that it was being done in the same way that the statute was requiring it to be done, but it was a new service provider drafting the policy. So I believe he testified he was not exactly certain as to what the impact of the change was.
Okay. So let's say that we agree that this policy was either being actively enforced or intended to be enforced against Mr. Forrester. What then is your argument as to what the threshold for adversely affected affected by the policy or by the enforcement is?
Well, I mean, unfortunately, it seems to be a matter of first impression as to what the interpretation of that standard is going to be adversely affected. I know that Mr. Forrester and his counsel have argued a slew of federal cases interpreting the First Amendment and the Second Amendment and Article 3. I think it's important to note that there are no constitutional claims in this lawsuit. This lawsuit was a one-count complaint, and the one count was that the school board of Sumter County violated the state's preemption of firearms and ammunition. As a result of that position, we believe that adversely affected has to be something more than essentially what Mr. Forrester offers, is that he felt unsafe because he couldn't drive his car with his gun to school because he couldn't have the gun in the car at school, and that some students may have seen him walk out to his car. Now, that was interspersed with.
Well, let me ask this: adverse effect as a standing standard is in Florida's jurisprudence is a pretty well played out standard in terms of an individual seeking to challenge a constitutional provision. Why would we not, given the similarities between that line of Florida case law and the language employed by the legislature here, apply the same meaning to that phrase, adversely affected?
Why wouldn't you apply the same standard?
Yeah, why would we not apply the same standard? In other words, we assume that the legislature, when they adopt a term of art, bring with it everything that's been imposed on that term. It is a well-established standard in Florida jurisprudence for challenging the constitutionality of a statute. It seems to be used in the same manner in the statute. So I'm just looking to see whether you think it would be an error for this court to adopt the same meaning that the courts have imposed on adverse effect in the context of constitutional challenges, or if you think some other standard applies.
Well, I don't have another standard to offer as an alternative to you. I would be cautioned that this is not a constitutional claim. Again, we raised that argument several times throughout the course of the litigation, and the complaint was never amended to add a constitutional claim, whether it's state or federal constitutional claim. It's always been pled as a violation of the statute allowing only the legislature to make any changes to weapons and firearms legislation. So that would be my only concern, that's not the claim that was brought. That's not the claim that he's raised. Does he mention the word Constitution a couple of times in the pleadings? Yes, but it is obviously just a one-count complaint for a violation of a statute, and that statute happens to have a specific standing standard for whether somebody has the ability to bring a claim. And in Mr. Forrester's situation, the two incidents that were any evidence potentially he could get of a adversely affected or negative impact, neither one of those had anything to do with enforcement of the statute. They had, or enforcement of the policy of the school board. They had to do with enforcement of the criminal statute that prohibits any weapons or handguns or firearms inside a classroom building.
And as the adverse effect, why isn't mere infringement, and of course recognizing that it's not framed as a constitutional issue, but why isn't Mr. Forrester's inability to transport his firearm in his vehicle an adverse effect? Just that sole fact alone.
Well, I don't think the plaintiffs at any point have argued that the school board is not entitled to pass a policy which would prohibit that. I mean, the policy that they were attempting to pass, obviously the lower court found a couple of problems with that policy, but the policy they're attempting to pass is the policy that's permitted by the statute. It specifically allows for the policy to prohibit any firearms in cars on school property, which is the exception to the exception. No one's argued that we can't do that or that's not a legitimate exercise of the school board's authority. They've argued, and the court agreed with them to some extent, that that the attempt by the school board had some issues that needed to be corrected. But so how is Mr. Forster?
My question is that issue has not been cross-appealed. We're assuming that for the purposes of this appeal. So assuming that the policy is in violation of 790.33, all we're looking at is whether there's an adverse effect. So my question is, why is not his inability to carry his firearm with him in his vehicle an adverse effect? If we're only looking at the narrow issue of what a potential adverse effect could be under the statute.
Well, number one, Your Honor, there's been no evidence that he ever had a firearm in his vehicle before this, and his merely saying it, that he wanted to have it. I mean, what if he said he didn't feel safe unless he had a machine gun in his car? Over what would prevent him from being able to argue that that's an adverse effect because he wanted some other kind of firearm or weapon that was regulated in a different way that he wanted in his car? I don't think that that there's a couple of cases that we had cited in our brief that talk about the issue that the right to have a gun is not a unlimited right on what you can do or not do. He wants to be able to have it in his car in the parking lot. Well, I mean, just because that's what he wants doesn't make that something that he is entitled to receive.
So if I frame it this way, that adverse effect in Florida's case law has ensured that there's something more than merely speculative. In other words, somebody couldn't apply to Sumter, maybe somebody couldn't apply to Sumter County School Board and say, well, I would apply there and I would get a job there and then I would start earning a salary, except I'm never going to apply because I want to be able to carry a firearm with me. Whereas Mr. Forster's situation is more concrete. He is subject to the policy, period. In terms of injury in fact and a broad standing standard, why is just that fact that he is not subject to the policy an adverse effect?
Because then there would be no reason to have the standing argument if all you had to do was be somewhere or be hired in a particular job and you have standing to contest something. I mean, what's the difference between that and every other employee of the school board? Whether Mr. Forster hasn't brought a gun to school that we're aware of. He wasn't searched at any point in time because he had a gun in school. So what would make his situation different from any other employee? There would be no standing. It would just be anybody who claims that they want to bring something to school or claims that they want to have a gun in the classroom would have standing to complain about it. That would basically eliminate this test.
Let me ask it this way. Is it the school board's position that he needed to be disciplined, fired, or ranked poorly, or in some other way had his employment impacted in order to show an adverse effect?
Yes, sir. I think he would have to show that he was actually, it would be one way to show adverse effect if he was had been disciplined, he could claim that there was some relationship between an action that occurred in the enforcement of the policy and his relation with either the students or the administration, or change in what his evaluation was at some point in time. All of those would be small but potentially adverse effects.
So even if the school board tells him directly that we are going to enforce this policy against you, he still has to violate the policy in order to have standing under this statute.
I think if you say you will be disciplined if you don't do this, then I think that would create standing. Yes, sir. But that's never been done in this case.
Well, I just circle back to his testimony in his deposition then about his right to park there. How is that not enough to give him standing?
Because, I mean, his right to park there, because if there was not an issue raised about the way that the policy was drafted, if the word firearms had been interchanged for the word weapons in the policy, then under the preemption statute, Mr. Forrester would be prohibited from parking in the parking lot with a gun in his car. So that would mean that everybody would be able to make a claim that, well, they weren't allowed to have a gun in their car, whether they ever intended to have a gun in the car or not. So they're bringing a lawsuit and claiming damages because they're not allowed to park where they want to.
Thank you.
Excuse me?
Mr. Hawks, sorry, you're out of time. Thank you for your argument.
Oh, thank you.
I think I'd like to start with 790.33, the preemption statute. And if we look at 790.33, in basically 790.33(2)(b), it says the intent of this section to deter and prevent the violation of this section and the violation of rights protected under the Constitution. So the whole purpose of the preemption was to protect Floridians' rights under their Constitution that they have adopted. And then if we go to, it's not just wanting to carry a firearm in your car because you might feel safer, as if we can dismiss that as irrelevant. The legislature says that the whole purpose of allowing citizens to carry a firearm securely encased in their automobile under 790.254, construction, this act shall be liberally construed to carry out the declaration of policy herein in favor of the constitutional right to keep and bear arms. So we do think that by pleading a violation of the preemption statute, we are pleading that they violated the Constitution. And we don't think that there's special words or magic words. We point to 790.33 because this is the legislature acting to support those rights. So he did have a right to carry his gun in his car. He wanted to carry his gun in his car. He does, and it's in the record, he does have a concealed carry permit. So it's not just some employee who thought maybe I can retain an attorney and pay some filing fees and write to the attorney generals and go talk to and get my car searched. And you know, it was clearly enforced against him. The whole, and there was never at trial, there was never this argument that we were just enforcing the criminal laws. I'm sure they probably would have if they had found a gun. But we never got to that point. And of course, these complaints were anonymous, which I think is significant. But we would ask the court to reverse and remand with instructions that the court fashion relief, including fees and costs, and a prohibition against enforcing this rule, to say that this rule somehow prohibits the carrying of a firearm securely encased in an automobile. And if there's any questions, I'll be happy to answer them. I would thank the court for your time and your attention.
All right, thank you both for your argument.